चलिए आज डिस्कस करते हैं आत्माराम की जजमेंट के बारे में, जो कि रिलेटेड है दिल्ली रेंट कंट्रोल और दूसरे रेंट प्रोसीडिंग्स के संदर्भ में, इन विच देयर आर प्रोविजंस ऑफ पेइंग द ऑक्यूपेशनल चार्जेस मीन प्रॉफिट्स टू द लैंडलॉर्ड व्हेन he has got the decree or order in his favor for eviction of the tenant. So what are the provisions under which the landlord can get the mean profit or the occupational charges when he got the decree or judgment in his favor from the tribunal or the trial? So the law is very clear as per the judgment of the Atmaram that the landlord who has got decree in his favor from the tribunal or the rent controller, he can get mean profit and occupational charges as a fruits of the decree, because under section 2L and 2M the tenant, even after the termination of tenancy, remains the tenant, but once the decree and the order is passed, he ceased to be a tenant and the lessee. In that case, as per the definition of Delhi Control Act provided under subclause L of section 2, saying that a person, a tenant whose tenancy is terminated, remains the tenant after termination of the tenancy, but in case of the judgment in his against him, he ceased to become the tenant, so he can be liable to pay the occupational charges as per the identical or similar properties situated or placed in the similar position nearby. But there are certain other conditions also. These provisions were provided for safeguarding and giving the occupational and mean profits to the landlord in cases wherein he could have the fruits of the decree and the order, but at the same time the equity, reasonableness and the natural justice has to be followed, which is provided under para 19 of the Atmaram's judgment. So in that case, this issue was discussed in detail with reference to the doctrine of merger as well, wherein it was stated that once the appeal or revision is filed against the order of eviction and the judgment, then the order of the appellate court and the Supreme Court merges in the decree of the trial court finally. Until and unless there is finality of the decree and judgment, the tenant cannot be compelled to pay rent, contractual rent, more than contractual rent as provided in the agreement. But the distinguishment was made by the Supreme Court while referring to one of the judgment of the MP High Court and the definitions of the tenant provided under section 2L and M under Delhi Rent Control Act. So these were the distinguishment which were provided in the said judgment, on the basis of which the Atmaram judgment is being followed by the High Court. Thank you.